Does the Civil Rights Act cover age discrimination? Have you ever wondered if the Civil Rights Act of 1960 includes protections against age discrimination? This question is important as it helps us understand the scope of civil rights laws in the United States. The Civil Rights Act of 1960 is a landmark piece of legislation. It prohibits discrimination in employment and public accommodations based on race, color, religion, sex, and national origin. However, it is not included in this list. So, what does that mean for age discrimination? It means that if someone faces discrimination at work because of their age, the Civil Rights Act does not cover that situation. Instead, age discrimination in employment is addressed by a different law known as the Age Discrimination in Employment Act of 1967. This law specifically protects workers who are 40 years of age or older. It prevents discrimination in hiring, promotions, wages, termination, and benefits based on age. The Age Discrimination in Employment Act also restricts mandatory retirement in most sectors, although there are some exceptions for high-level executives. This separation of laws highlights how different types of discrimination are treated under U.S. law. From a libertarian perspective, the Civil Rights Act represents a significant federal intervention in private matters. Libertarians generally advocate for limited government and individual liberty. They may support the idea of opposing discrimination, as it aligns with respecting individual rights. However, they often question the extent of government involvement in regulating private employment decisions. Libertarians might argue that voluntary solutions or private contracts should play a larger role in addressing discrimination rather than relying solely on broad federal mandates. This viewpoint adds another layer to the discussion about civil rights and government power. In summary, the Civil Rights Act of 1960 does not cover age discrimination. Instead, that issue is specifically handled by the Age Discrimination in Employment Act of 1967. Understanding these distinctions helps clarify how civil rights protections developed over time and how they relate to the role of government in regulating employment practices.